This case opens with a bench warrant, a contempt finding, and a woman claiming the whole mess started because she was never properly notified. But this is bigger than just missing one hearing. She says the warrant, the contempt order, and even the public YouTube record have damaged her professional reputation in other cases. So now the courtroom is facing two major questions. Did she truly have notice? And if she didn't, should everything that followed be pulled back? Stay with this one because the paperwork timeline is where things get very interesting.
Court does call the case of Fixing Housing 401k versus Erica and Aaron Ward in regards to the bench warrant issue. This is a matter involving Donna Tope. Ms. Tope. State your name.
Donna Tope. I'm hearing on behalf of myself.
Ms. Tope, I had issued a bench warrant for your arrest for failure to appear at a show cause hearing, which I know that you had notice of. You filed a motion in this case to remove and expunge the court's order for contempt and the warrant for your arrest. That is your motion before the court today.
Yes.
Go ahead.
So I would like to put this on the record for my own purposes and also for YouTube. The YouTube that was recorded when you issued this bench warrant has been used against me in my professional capacity and for other cases. And therefore, I would like to have this on the record.
Now we're getting into the core of her defense, and notice how she approaches it. Not with emotion first, but with dates, emails, exhibits, and mailing records. That's a smart courtroom move. She's trying to show that this wasn't simple non-compliance. It was a notice failure that spiraled into a contempt finding and an arrest warrant. She also makes it clear this has affected her beyond this courtroom, especially professionally. And that raises a bigger issue. When court records go public, the consequences can extend far beyond the hearing itself. Do you think she's making a strong due process argument here?
Have what on the record?
What I'm going to tell you now in my defense.
Go ahead.
Okay. It's my motion. The following enumerated facts support my motion to remove and expunge from every record, including the YouTube video, A, your order for contempt, your warrant issued for my arrest, and your order to hold me under arrest on $10,000 cash bail. I received the judge's final docket for hearings set for Tuesday, February 3rd, 2026 at my email address on Monday, February 2nd from Ms. Weedling. I opened the email the morning of Tuesday, February 3rd, because I am a party in a completely different case before this court, and I looked for something on that case on the docket. To my surprise, the docket for 2 p.m. that very afternoon had me listed for a show cause hearing on a case for which I am neither a party nor an attorney. Not having had any notice of appearance for this hearing, I was not able to get to the court in time. So I sent Ms. Weedling the email, which I attached on my motion as Exhibit A, explaining that to the court. I receive all of my business mail at Post Office Box 1283 in Ann Arbor, Michigan, 48106. I check my mailbox weekdays after 5 p.m. On Thursday, February 5th, 2 days after the unnoticed show cause hearing on the court's February 3rd docket, I sent Ms. Weedling the email and photos provided at Exhibit B. The email describes what I received that morning, Thursday, February 5th, 2026, in my post office box, 2 days after the hearing was held. The photos included with my email to the court are of a motion affidavit in order to show cause signed by Judge Simpson, along with the postmarked envelope they were mailed in. Exhibit C is hard copies of those legal papers and the envelope. The motion at number 2 Page 1 states, I am being held by the judge in contempt for filing a pleading without my client's knowledge nor being the attorney of record. At number 3 on page 1, Judge Simpson requests an order to show cause why I should not be found in civil contempt of court. Can you attach it for me? Thank you. At item 5, page 2, I am ordered to appear before the court on February 3rd at 2 p.m. At 7 on page 2 of the order to show cause, it states that a copy of this order must be served by mail on the person ordered to appear, which is me, at least 14 days before the hearing, which had been set for a hearing on the docket for February 3rd at 2 p.m. The judge's signature is dated January 20th. The envelope is postmarked January 28th. The date the post office mailed it, which is only 6 days before the hearing date of February 3rd, which is not the quote, service by mail within 14 days required by the judge's signed order. I received the order at my address on February 5th, 2 days after the hearing was held, and only 8 days after it was mailed, which is 6 days shy of the required 14-day notice by mail.
This is the most important part of her argument. She says the order required service by mail at least 14 days before the hearing, but the envelope was postmarked only 6 days before, and she says she didn't actually receive it until after the hearing had already happened. If that timeline is accurate, that's not a minor technical error. That goes straight to fairness and notice. And once a contempt ruling, bench warrant, and $10,000 cash bond are all built on top of that, the stakes become enormous. So what matters more here? The court's record or the mailing timeline she's putting in front of the judge?
The facts are that I was not properly served nor properly noticed of the hearing at which Judge Simpson found me in contempt for not appearing. The further facts are that in finding me in contempt for not appearing, Judge Simpson issued a warrant for my arrest and demanded an excessively punitive cash bail of $10,000, or so I was told by a person who was in the courtroom when Judge Simpson put his order for my arrest on the record. Based on what I have provided, the judge's motion and order and the mailing envelope, I am asking for the following relief from Judge Simpson. Please retract, remove, and/or expunge all records of the order for contempt, the bench warrant, and cash bail issued by the judge, so that there is no evidence out on the web that the judge issued the order, the warrant, and the excessively punitive bail. I include court records, transcript records, and the YouTube video of the judge's orders that another attorney alerted me to in cases that I am appearing in 3 other circuit courts, and reissue with proper notice to me the show cause hearing the judge wishes to impose upon me. I am perfectly happy and willing to appear at a show cause hearing if I have proper notice. I did not.
This is your proper notice. You had notice. I will stand on the record that I made that day that you had notice of that hearing and that you failed to appear.
And
My staff indicated that. You can argue with me all you want, Ms. Toad.
And here's the tension point. The judge is not backing off the original position. She says the defendant had notice and makes it clear she's standing on the prior record. But then the issue gets even more serious because now the judge connects the bond amount to alleged conduct in the case, filing pleadings after being removed without the client's knowledge and causing delay that cost the other side money. That is a major accusation. At this point, this is no longer just about a missed hearing. It's about professional conduct, courtroom credibility, and whether the court believes her explanation at all.
What I will do, though, because you have part of the reason that the bond is set in the amount that it was, is because you had basically been removed from the case, this case. You had filed a pleading, you signed it. Your former client had no knowledge of it.
That's not,
Was delayed.
not correct.
You want to know what? Do not interrupt me, because then there's going to be a whole other problem. Your client stated on the record they did not have no knowledge of it. Defense counsel or plaintiff's counsel had to respond. The amount of the bond is the amount of billings that the plaintiff had incurred based upon you filing pleadings when you weren't supposed to and the delay that you caused. It was set in that amount. What I will do is I will cancel the bench warrant. I will reset your show cause hearing. So here's your notice for April 14th, 2026, 9 a.m. Thank you.
This is one of those rulings where both sides get part of what they wanted. She does not get the contempt issue erased right here, and the judge does not admit the original notice was defective. But the bench warrant is canceled, and the show cause hearing is reset with direct notice given in open court. That matters a lot. From here on out, there can be no confusion about the next hearing date, and the judge's mention of bringing witnesses and possibly counsel tells you the next round could go deeper into the underlying allegations. In other words, this hearing solved the immediate crisis, but not the real conflict.
Have all your witnesses, and if you wish to be represented by counsel, you need to have counsel present at that proceeding.
Thank you.
Are you understood? Am I understood?
Clearly.
Thank you. Well, that was fun.
So the takeaway is this. She argued that improper notice led to a contempt finding, a bench warrant, and a $10,000 cash bond that she says harmed her professionally. The judge disagreed that notice was lacking, stood by the prior record, and tied the bond to alleged delay and costs caused by her actions in the case. But the court did cancel the bench warrant and set a new hearing date, which means this dispute is far from over. Cases like this show how fast procedural problems can turn into major legal and reputational battles. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.